Legal disclaimer. The following content is strictly for educational and entertainment purposes only. This video does not constitute legal advice, attorney-client privilege, or a replacement for professional legal counsel. Employment laws in the United States vary significantly by state, jurisdiction, and specific industry regulations. The information presented here is a general overview of common legal concepts and contractual elements found in U.S. employment agreements. It is not tailored to your specific situation, location, or employment status. If you are currently reviewing an employment contract, facing a dispute with an employer, or considering signing a severance agreement, you must consult with a qualified labor and employment attorney licensed to practice in your specific state. Do not make decisions that impact your livelihood, career trajectory, or financial security based solely on YouTube content. Contract law is nuanced. A single word or the placement of a comma can alter the legal enforceability of a clause. By continuing to watch, you acknowledge that you alone are responsible for your due diligence, and that the creators of this content accept no liability for actions taken based on this information. Always read what you sign, and when in doubt, hire a professional to review the fine print before your pen hits the paper. The hook. Picture this scenario. You have just landed your dream job. The salary is 20% higher than what you are making now. The benefits package looks incredible. The title is exactly what you have been working toward for the last 5 years. You are sitting in HR, or maybe you are at home staring at a DocuSign email and the pressure is on. They want the signed offer letter back by Friday. You skim the 10-page PDF. It looks like standard boilerplate language. You see words like confidentiality, non-solicitation, and invention assignment. You assume this is just standard corporate safety talk. You sign it. You celebrate. You start the job. Fast forward 2 years. You decide it is time to move on. Maybe you want to start your own consulting firm, or maybe a competitor has offered you a massive signing bonus. You hand in your 2 weeks' notice, expecting a handshake and a farewell cake. Instead, you get a cease and desist letter delivered to your home address by a courier at 7 p.m. on a Tuesday. Suddenly, you are being sued for $50,000 in liquidated damages because you didn't realize that standard contract you signed contained a repayment clause for the training they provided you in the first month. Or perhaps you are frozen out of your entire industry for 18 months because that boilerplate non-compete clause was actually enforceable in your specific state, and now you legally cannot work for any company that makes over 10% of its revenue from a similar product line. This is not a horror story from a movie. This is the reality for thousands of American workers every single year. A study by the Economic Policy Institute suggests that millions of workers are currently bound by non-compete agreements, often without even realizing the strictness of the terms until it is too late. The terrifying reality of the United States employment system is that while we are largely an at-will employment nation, the contract you sign on day one can effectively override your freedom to work for years after you leave. Most people believe that unless they are a C-suite executive or a high-level engineer, employment contracts are just formalities. That is a dangerous lie. In today's corporate environment, companies are slipping restrictive covenants into entry-level and mid-management contracts that were once reserved for CEOs. We are talking about clauses that claim ownership over your side hustles, clauses that force you to pay back your signing bonus if you leave before 24 months, and arbitration agreements that strip you of your right to sue in court if you are harassed or discriminated against. The open loop that should keep you up at night is this. There is a specific clause, often buried on page 7 or 8 of standard employment agreements, that effectively gives your employer ownership of your intellectual property, even things you create on your own time on your own laptop on the weekends. Do you know what the specific wording looks like? Do you know how to strike it out before you sign? If you don't, you are walking through a minefield blindfolded. The promise. In this 10-part deep dive masterclass, we are going to dismantle the U.S. employment contract piece by piece. We are not just going to define terms, we are going to look at the strategic architecture of how companies protect themselves at your expense. By the end of this series, you will possess the ability to read a legal document with the eyes of a seasoned negotiator. You will understand exactly what leverage you actually hold during the hiring process, leverage that HR departments pray you never figure out. This is not just about avoiding lawsuits. It is about maximizing your career equity. When you understand the terms of your employment, you understand the value of your labor. We are going to cover the big 3 restrictive covenants: non-competes, non-solicits, and non-disclosures. But we are going deeper than the basics. We are going to analyze clawback provisions, the mechanism employers use to pull money back out of your bank account years after they paid it to you. We will examine the dangerous rise of traps, training repayment agreement provisions, which some legal experts have compared to modern-day indentured servitude, trapping employees in low-paying jobs under the threat of massive debt. You will learn the difference between an offer letter and a binding employment contract, a distinction that confuses the vast majority of the workforce. We will discuss the specific red flags that should make you walk away from a job offer entirely, no matter how high the salary is. We will talk about integration clauses, which essentially say that any verbal promise the recruiter made to you, like, "Oh, you can totally work from home on Fridays," is legally void if it is not written in the final document. We will also arm you with specific scripts and phrasing you can use to push back. You will learn how to say, "I am not comfortable signing this specific section as it is currently written," without looking difficult or losing the job offer. We will explore the concept of consideration in contract law, the legal requirement that you must get something of value in exchange for giving up your rights, and how to use that to demand more money or better benefits in exchange for signing restrictive clauses. This series solves the problem of information asymmetry. The company has a legal department, outside counsel, and an HR team whose entire job is to minimize the company's risk. Until now, this series levels the playing field. We are taking the complex, intentionally obfuscated language of legal contracts and translating it into plain English so that you can protect your future earnings, your intellectual property, and your professional freedom. We are going to look at historical trends where courts have thrown out contracts for being unconscionable, and we will look at cases where the employee lost everything because they missed a single sentence. We will discuss the choice of law provision, which might subject you to the laws of a state you don't even live in, simply because the company's headquarters are there. This affects your taxes, your rights, and your ability to dispute termination. If you are a freelancer or independent contractor, do not tune out. We have a dedicated section coming up on the misclassification of employees versus contractors and how the IRS views these contracts differently than your employer might. The IRS crackdown on worker classification is heating up, and your contract is the first line of defense or the first piece of evidence used against you. This is about moving from a passive participant in your career to an active owner of your professional destiny. When you sign your name, you are binding your future self to a set of rules. You owe it to your future self to understand exactly what those rules are. Whether you are an entry-level graduate signing your first W-2 agreement, a mid-career manager negotiating a severance package, or an executive looking at stock option grants, the principles we will cover in this masterclass are universal and critical. We are going to be thorough. We are going to be detailed. We are going to look at the scary stuff so that it stops being scary and starts being a tool you can use. Do not skip a second of this. The difference between a successful exit and a financial nightmare often comes down to who read the contract better. Let's begin the deep dive. Let's start with a distinction that 90% of the workforce gets wrong. This misunderstanding is the root cause of almost every employment dispute that doesn't involve actual discrimination. It is the confusion between an offer letter and an employment contract. You might think they are the same thing. You might think that because you received a PDF on company letterhead saying, "We are pleased to offer you the position of senior analyst at a salary of $85,000. You have a binding contract." You likely do not. In the vast majority of cases in the United States, what you are holding is legally considered a non-binding proposal of terms, often completely revocable by the employer right up until the moment, and sometimes even after you start the job. To understand why, we have to look at the bedrock of American labor law, the doctrine of at-will employment. Unless you live in the state of Montana, or you belong to a union with a collective bargaining agreement, or you are a high-level executive with a specifically negotiated, for-cause agreement, you are an at-will employee. This means the relationship can be terminated by either party at any time, for any reason, or for no reason at all, as long as the reason isn't a legal discrimination based on protected classes like race, gender, or religion. Here is the scenario that plays out in law offices across the country. Imagine you are working a stable job. You get headhunted by a flashy startup. They send you an offer letter. It outlines your title, your start date, your salary, and a potential 10% performance bonus. It looks official. You feel secure. You sign the letter, send it back, and then you walk into your current boss's office and quit. You lose your seniority, your accrued vacation time, and your stability. 2 days before your start date at the new company, the startup loses a major funding round. They call you and say, We are rescinding the offer. You are now unemployed. You have no job to go back to and no job to go forward to. You look at that signed offer letter and you want to sue for breach of contract. In an at-will jurisdiction, courts generally hold that because the employer could have fired you 1 second after you started the job for no reason, they can also decide not to hire you 1 second before you start. The offer letter, in this context, offers almost no protection for your continued employment. It is merely a statement of what the company intends to pay you if they decide to keep employing you. However, the dynamic shifts when we introduce the actual employment agreement or the Proprietary Information and Inventions Agreement, PIIA. This is usually a much longer, denser document sent to you during the onboarding process, sometimes after you have already accepted the offer letter. This is where the bait and switch happens, and it relies on a specific legal mechanism called the merger clause or the integration clause. You need to listen closely to this because this clause is designed to erase your memory, legally speaking at least. An integration clause is a paragraph, usually found near the end of the formal contract, which states something to the effect of, "This agreement constitutes the entire agreement between the parties and supersedes all prior agreements, understandings, and negotiations, whether written or oral." Let's translate that. Remember that email where the recruiter told you, "Oh, don't worry, we are fully remote. You never have to come into the office?" Or the offer letter that mentioned a target bonus. If you sign a formal employment contract that contains an integration clause, and that contract says work location is at the discretion of the company, or fails to mention the bonus, those previous promises are often instantly vaporized. They no longer exist in the eyes of the law. The court looks at the contract with the integration clause and says, "This document is the only thing that matters." This creates a dangerous gap for employees. You make life-altering decisions based on the offer letter and verbal promises, but you are bound by the employment contract. This is why you must never resign from your current position until you have seen, reviewed, and signed the final long-form employment agreement, not just the preliminary offer letter. If the company says, "Oh, we will sort out the formal contract on your first day," that is a massive red flag. You are stepping into a high-stakes environment without a parachute. Let's dig deeper into promissory estoppel, because this is the one legal theory that might save you in a revoked offer nightmare. But it is incredibly difficult to prove. Promissory estoppel essentially argues that even if there wasn't a binding contract, the employer made a promise that they reasonably expected you to rely on, you did rely on it to your detriment by quitting your job or moving cities, and now injustice can only be avoided by enforcing the promise. There is a famous legal case study often taught in law schools, Grouse versus Group Health Plan, involving a pharmacist. He was offered a job he accepted, and he turned down another offer from a different employer. Then the first employer revoked the offer because they couldn't get references quickly enough. He lost both jobs. The court actually found in his favor, not because he had an employment contract, but because he had a right to rely on their offer in good faith. However, relying on case law like this is risky, expensive, and stressful. It is better to prevent the situation than to fight it in court. Now, consider the executive exception. If you are moving into the C-suite or a high-level VP role, the rules change. In these tiers, the offer letter and the employment contract are often negotiated simultaneously, as one comprehensive document. These contracts often opt out of at-will employment. They include for-cause termination clauses. In a for-cause agreement, the company cannot just fire you because they feel like it. They must prove you were negligent, committed a crime, or failed specific performance metrics. If they fire you without cause, they owe you a severance package usually defined in the contract, maybe 6 months or a year of salary. This is the protection most workers think they have but rarely do. If you are a standard employee, you can try to negotiate a notice period into your agreement. This is a clause that says the employer must give you 2 weeks or 1 month's notice before termination, or pay you in lieu of that notice. While they likely won't give you a full, for-cause protection, getting a guaranteed notice period is a small win that provides a financial buffer. Another critical component of the anatomy of these documents is the incorporation by reference. Your offer letter or short-form contract might say, "Employee agrees to abide by all policies in the employee handbook." This sounds innocent, but have you read the handbook? In many states, courts have found that terms buried in an employee handbook can be legally binding if the contract explicitly incorporates them. That handbook might contain your arbitration agreement, stripping your right to a jury trial, your social media policy, restricting what you can post online, or even policies regarding vacation payout upon termination. By signing the one-page offer letter that references the handbook, you are blindly signing a 100-page legal code that governs your daily life. You must ask for the employee handbook along with the offer letter. HR will find this annoying. They will say, "Oh, you get that during orientation." You must politely persist. "I would like to review all binding documents referenced in the offer before making my final decision." If they refuse to show you the rules of the game before you join the team, ask yourself what they are hiding. We also have to talk about consideration. In contract law, a contract is only valid if there is an exchange of value. You give labor, they give money. This concept becomes vital when a company tries to change your contract after you are already employed. Imagine you have been working there for 5 years. Suddenly, HR calls you in and says, "We need everyone to sign this new non-compete agreement." You are already an employee. You are already getting paid. If you sign it, are you getting anything new? In some states, continued employment, not getting fired, is considered enough consideration to make the new contract valid. But in other states, like Pennsylvania or Washington, courts have historically trended toward saying continued employment is not enough. The company must give you something new, a bonus, a raise, a promotion, in exchange for you signing that new restrictive covenant. If you are ever handed a new contract to sign while you are already employed, do not just sign it to be a team player. You are giving up rights. Ask, is there any additional consideration associated with this new agreement? You might just talk yourself into a signing bonus, or at the very least, you will signal that you understand the game. But the most dangerous clauses are not the ones that define your salary or your title. They are the ones that define what you cannot do. As we move into the next section, we are going to open the hood on the big three. These are the clauses that can freeze your career, empty your bank account, and drag you into courtrooms for years. I'm talking about non-competes, non-solicits, and NDAs. You might think non-competes are banned because you saw a news headline about the FTC. You would be dead wrong to assume you are safe. The battle over non-competes is raging right now, state by state, judge by judge, and if you assume they are unenforceable, you might be walking into a trap that will cost you your next job. This is the most dangerous misconception in the current American job market. The belief that the Federal Trade Commission, or FTC, has already swooped in and made non-compete agreements illegal nationwide. If you are operating under this assumption, you are exposing yourself to catastrophic legal risk. While the FTC did propose a sweeping ban on non-competes, declaring them an unfair method of competition, that rule immediately faced massive legal challenges in federal court. As of right now, for the vast majority of workers in the vast majority of states, the ban is not in effect. The old rules still apply. And the old rules are a patchwork nightmare of 50 different state laws that can trap you in a stranglehold. Let's dissect the big three restrictive covenants, starting with the most aggressive one, the non-compete. A non-compete agreement essentially states that for a specific period of time after you leave your job, usually 12 to 24 months, you cannot work for a competitor within a certain geographic radius. The intent, theoretically, is to prevent high-level executives from taking trade secrets across the street to a rival. But in practice, these clauses have trickled down to sandwich makers, hairstylists, and entry-level coders. There was a famous case involving the sandwich chain Jimmy John's, which required low-wage workers to sign agreements barring them from working at any other establishment that sold submarine, hero type, deli-style, pita, and/or wrapped or rolled sandwiches within 2 miles of any Jimmy John's location. Think about the absurdity of that. A student making minimum wage could effectively be banned from working in the food service industry in their entire city. While Jimmy John's eventually dropped these under public pressure, thousands of companies still use similar language today. The enforceability of a non-compete generally hinges on 3 factors: duration, geography, and scope. Duration is usually simple. Courts rarely enforce anything over 2 years. Geography is where it gets messy. If you are a sales rep covering the Northeast Territory, a ban on working in the United States is likely too broad and might be thrown out. However, if the company is a global software firm and your role was remote, a court might actually uphold a nationwide or even global ban because the market is everywhere. Scope is the trickiest part. Does the contract ban you from working for a competitor in any capacity, or just in a similar capacity? If you are a software engineer for a bank, and you leave to be a janitor for a rival bank, a broad non-compete might technically forbid it. A reasonable non-compete should only stop you from doing the same job, but contracts are often written to be as terrifyingly broad as possible to scare you into compliance. Crucially, you must know where you live. If you work in California, North Dakota, Oklahoma, or Minnesota, non-competes are largely unenforceable. California is the gold standard here. Their labor code effectively voids these agreements, which is a major reason why Silicon Valley flourished. Engineers could freely move from Intel to Apple to Google, cross-pollinating ideas. But if you live in Florida, the courts are notoriously pro-employer and will vigorously enforce these contracts to protect legitimate business interests. If you find yourself in a state that enforces them, you need to understand the blue pencil doctrine. In some states, if a judge sees a non-compete that is too broad, say it bans you from working for 10 years, the judge will throw the whole contract out. You walk away free. But in blue pencil states, the judge is allowed to simply cross out 10 years, write in 1 year, and then enforce the rest of the contract against you. This incentivizes employers to write wildly unfair contracts, knowing the worst that will happen is a judge might scale it back to what they wanted anyway. Next, let's look at the non-solicitation agreement. This is the silent career killer. Even if a company can't stop you from working for a competitor, they can stop you from taking your book of business. Non-solicits come in two flavors: non-solicitation of clients and non-solicitation of employees. Non-solicitation of clients means you cannot try to get your old customers to follow you to your new firm. This sounds fair until you look at the definition of solicit. In the digital age, courts are struggling to decide if updating your LinkedIn profile to say, "I'm now a VP at competitor X," counts as soliciting your old clients who follow you. Some aggressive employers argue that it does. Imagine you are a hairstylist or a financial advisor. Your clients are loyal to you, not the building you work in. A strict non-solicit can effectively starve you out of your industry. You might be allowed to work at the new salon, but you can't tell anyone you are there. You have to start your client base from zero. Then there is the non-solicitation of employees, often called an anti-poaching clause. This prevents you from recruiting your former colleagues. Let's say you leave a toxic company to join a great one. You want to save your work best friend. You tell them, "Hey, apply here, it's amazing." If you signed a non-solicit, you just breached your contract. You could be sued for the damages caused to the old company for losing that employee. This clause effectively traps groups of talented people in bad work environments because the one person who escapes cannot reach back to help the others. Finally, we have the non-disclosure agreement, or NDA. Everyone knows NDAs protect trade secrets, the recipe for Coca-Cola or the algorithm for Google search. That is valid. But modern NDAs have morphed into tools of silence. They often define confidential information so broadly that it includes marketing strategies, vendor lists, pricing models, and personnel information. That last part is the trap. Personnel information often includes your salary. But wait, under the National Labor Relations Act, NLRA, of 1935, most private sector employees have a federally protected right to discuss their wages and working conditions. That is a Section 7 right. Yet, thousands of U.S. employment contracts contain clauses that explicitly or implicitly forbid salary discussions under the guise of confidentiality. If your contract says you cannot disclose company financial data, and they count your salary as financial data, that clause is likely illegal under federal law. But companies keep it in there because they bank on you not knowing your rights. They rely on the chilling effect. You stay silent because you are afraid of breaking the contract, even if the contract itself is breaking the law. Furthermore, NDAs are frequently used to cover up toxicity. If you settle a harassment claim, the company will almost certainly demand a strict NDA. But recent legislation, like the Speak Out Act signed in 2022, limits the enforceability of NDAs in cases regarding sexual assault and harassment disputes. Again, the law is changing, but the text in the PDF they sent you probably hasn't. Here is a practical imagine-if scenario to tie this all together. Imagine you are a graphic designer. You sign a standard agreement. 2 years later, you freelance for a different agency on the weekend. Your old boss finds out. They sue you for breach of the non-compete, working for a competitor, breach of the non-solicit, because the new agency has a client your old agency once pitched to 5 years ago, and breach of the NDA, because you used a similar file naming convention that you learned at the old job. Even if you win in court, even if you prove the non-compete was too broad, you still lose. You lose because you have to pay a retainer to a lawyer. You lose because you have to spend 18 months in depositions. You lose because the stress impacts your new job. The company doesn't sue you to win. They sue you to send a message to the employees you left behind. Don't you dare try to leave. The strategy here is in terrorem, a legal term meaning in fear. The contract is a weapon of fear. But there is a fourth clause. A clause so pervasive and so draconian that it makes non-competes look like child's play. This clause doesn't just stop you from working. It claims ownership of your thoughts. It claims that the app you built in your garage on Sunday morning, or the screenplay you wrote on your lunch break, or the patent you invented 3 years after you quit, might actually belong to them. This is the invention assignment clause, and it is the single greatest threat to your future wealth that you have never bothered to read carefully. This is where the corporate world effectively attempts to colonize your imagination. The invention assignment clause, sometimes hidden under the header intellectual property, or proprietary rights, is the section where you agree that anything you create during your employment belongs to the company, not you. On the surface, this makes sense. If Ford hires you to design a car engine, and they pay you a salary to design that engine, and you design the engine, Ford owns the patent. That is fair. That is work made for hire. You traded your labor for money, and the output of that labor belongs to the purchaser. But that is not how these contracts are written anymore. Modern invention assignment clauses are often drafted with a terrifying breadth. They don't just claim ownership of what you do at work. They claim ownership of what you do while you happen to be employed by them. The language usually looks something like this. Employee assigns to the company all right, title, and interest in and to any and all inventions, original works of authorship, developments, concepts, improvements, designs, or trade secrets, whether or not patentable, that the employee may conceive, develop, or reduce to practice during the period of employment. Did you catch the missing words? It didn't say during working hours. It didn't say using company equipment. It said during the period of employment. That means 24 hours a day, 7 days a week, 365 days a year. Let's run a deep dive scenario. Imagine you are a mid-level marketing manager at a large sneaker company. You have a passion for sci-fi novels. Every morning before work from 5 a.m. to 7 a.m., you write a book on your personal laptop in your own kitchen, drinking your own coffee. You finish the book. It becomes a bestseller. It gets optioned for a movie. If your employment contract has a broad, unmodified invention assignment clause, that sneaker company could theoretically sue you, claiming they own the copyright to your sci-fi novel. They could argue that because you were employed by them when you wrote it, and perhaps because you used knowledge of consumer trends you learned at the job to market the book, it belongs to them. You might think, that's ridiculous, a judge would never enforce that. Do not bet your financial future on what a judge might do. Litigation is expensive. Even if you win, the legal fees alone could bankrupt you before you see a dime of your royalties. This gets even stickier for software engineers and developers. Let's say you work for a cloud storage company. On the weekends, you build a mobile game. It has nothing to do with cloud storage. However, you accidentally test the game once on your company-issued laptop. Or maybe you use a snippet of open source code that you also used in a work project. That single intersection, using company resources, is often the poison pill. Most contracts explicitly state that any use of company equipment, supplies, facilities, or trade secret information grants the company ownership, regardless of when the work was done. That 5 minutes of testing on the company MacBook just cost you 100% of your equity in your side hustle. Now, there is a shield you can use, but it depends heavily on where you live. This is known as the statutory exception, most famously codified in California Labor Code Section 2870. This law states that an invention assignment agreement cannot apply to an invention that the employee developed entirely on their own time, without using the employer's equipment, supplies, facilities, or trade secret information. However, and this is a massive however, there are two critical exceptions to this protection. Even if you did it at home on your own time, the company still owns it if the invention relates at the time of conception to the employer's business, or actual or demonstrably anticipated research or development of the employer. The invention results from any work performed by the employee for the employer. Let's parse that. Relates to the employer's business. If you work for Google, what isn't related to their business? They do search, email, video, autonomous driving, health tech, AI, and hardware. If you work for a conglomerate, the scope of their business is effectively the entire economy. If you invent anything tech-related while working for a tech giant, they can make a plausible argument that it relates to their anticipated research. This creates an innovation trap. You are smart, you are creative, but you are paralyzed. You cannot build the next big thing because the company you work for owns everything you touch. But it gets worse. We need to talk about holdover clauses, or trailing assignment clauses. These are provisions that claim ownership of inventions you create after you leave the company. The clause usually says something like, any invention disclosed by the employee to a third party or described in a patent application filed within 6 months or 1 year after termination of employment shall be presumed to have been conceived during employment and shall belong to the company. Read that again. They create a legal presumption. If you quit your job on Friday, and on Monday you start building a startup and 6 months later you file a patent, your old employer can come knocking. They will argue, you couldn't possibly have come up with that complex idea in just 6 months. You must have thought of it while you were working for us. Therefore, it is ours. Suddenly, the burden of proof shifts to you. You have to prove you didn't think of it earlier. How do you prove a negative? How do you prove a thought didn't exist in your head 6 months ago? It is an evidentiary nightmare. This clause effectively renders you radioactive to venture capitalists. No investor will touch a founder who has a trailing assignment cloud hanging over their head from a previous employer. So, how do you protect yourself? You need to look for a specific page in the contract called Exhibit A, or the list of prior inventions. This is the most underutilized negotiation tool in the entire onboarding process. This is a blank page where you are supposed to list everything you own before you sign the contract. Most people leave it blank. They write none or not applicable. That is a fatal mistake. If you leave it blank, you are essentially confessing that you own nothing. If you have a side project, a half-finished novel, a piece of code, a consulting framework, or even a vague idea for a startup, you must list it here. You don't need to give them the source code or the full manuscript. You just need to identify it sufficiently to carve it out. You write, mobile application for dog walking optimization, currently in development. By listing it, you are creating a legal boundary. You are saying, this is mine. It existed before I met you. You cannot have it. If you invent something during your employment that is totally unrelated to work, you should technically notify the company and get a written waiver confirming they have no interest in it. I know that sounds scary. You don't want to tell your boss you are working on a side project, but getting that letter of non-assert is the only way to be 100% safe. Without it, you are building your castle on land that might belong to the king. The goal of the company is to monopolize your output. Your goal is to ring-fence your personal creativity. If you see an invention assignment clause that does not have the California exception language, or your state's equivalent, written into it, you must ask for it to be added. You can say, I want to ensure this clause complies with applicable state labor codes regarding personal inventions. It makes you look legally savvy, not rebellious. We have covered how you get in and how they own what you do while you are there. But what happens when it all falls apart? What happens on the day they call you into a conference room with a generic calendar invite? Termination. It is the moment every employee fears, but few understand the legal mechanics of. There is a massive financial difference between being terminated for cause versus without cause. One leaves you with a severance check and a clean reputation. The other leaves you with nothing and a permanent stain on your record. And the definition of cause is often buried in the definitions section of that contract you just skimmed. In the next part, we are going to dissect the mechanism of firing. We will look at good reason clauses, how you can fire your boss and still get paid, and we will expose the tricks companies use to manufacture cause so they don't have to pay you a dime. The moment an employment relationship ends is rarely a clean break. It is usually a collision of legal definitions that determines whether you walk away with a year's salary or just a cardboard box. To navigate this, you must understand the difference between being terminated for cause and being terminated without cause. This distinction is the financial pivot point of your entire contract. In a standard at-will arrangement, you might assume that because they can fire you for any reason, the label doesn't matter. You would be wrong. The label is everything. If you are an executive or have a negotiated contract, being fired without cause triggers your severance package. It unlocks the golden parachute. Being fired for cause cuts the cords and lets you plummet. So, how do companies define cause? In a fair contract, cause is reserved for serious offenses: embezzling money, committing a felony, or willful gross misconduct. Basically, you have to burn the building down or steal the safe. But companies sneakily expand this definition. They might define cause to include failure to perform duties to the satisfaction of the board, or violation of any company policy, or even insubordination. Let's play out a scenario. Your contract says cause includes failure to follow company policies. You are a sales director. You have a great quarter, but you forgot to file your expense reports on time 3 months in a row. Strictly speaking, you violated a company policy. If the company wants to get rid of you to save money, they can technically cite this administrative error as cause, fire you and deny your severance. They can argue you breached the contract. This is why you must aggressively negotiate the definition of cause before you sign. You want to narrow it. You want it to say willful and material breach. You want to change violation of policy to repeated and material violation of major company policies after written warning. You want to ensure that being bad at your job, simple poor performance, is explicitly excluded from the definition of cause. Being bad at your job should get you fired, yes, but it should be a termination without cause, meaning you still get your exit package. But what if you want to fire them? This brings us to the most powerful tool in the employee arsenal, yet one that 95% of workers have never heard of: the good reason clause. In legal terms, this covers constructive dismissal. Imagine you are a VP of marketing. A new CEO comes in. He doesn't like you, but he knows if he fires you without cause, he has to pay you $100,000 in severance. So he plays a game. He moves your office to a cubicle next to the bathrooms. He takes away your direct reports. He cuts your budget to zero. He tells you that you are now in charge of data entry optimization. He hasn't fired you. He is making your life miserable, so you quit. If you quit voluntarily, you get zero severance. A good reason clause protects you from this. It states that you can resign and still receive your full severance package if the company does specific things, such as materially reducing your base salary, relocating your job more than 50 miles away, or materially diminishing your title, authority, or responsibilities. If you have this clause, you don't just rage quit. You send a formal legal notice saying, "Due to the material diminution of my duties, I am exercising my right to resign for good reason." You just flip the script. You fired your boss and they have to write you a check. However, both cause and good reason usually require a critical safety mechanism called the notice and cure period. This is the referee whistle. If the company claims you messed up cause, or if you claim they messed up good reason, the contract should grant a 30-day window to fix it. If they say you are being fired for not hitting metrics, a cure period gives you 30 days to hit those metrics and save your job. If they cut your salary, you give them 30 days to restore it. If they fix it, the firing is off the table. If they don't, the termination proceeds. Without a cure period, you can be ambushed on a Friday afternoon with no chance to defend yourself. Now, let's look at the severance package itself. There is a widespread myth that companies are legally required to pay severance. Under U.S. federal law, let's say, they are not, unless you have a contract that guarantees it, or there is a specific company policy in the handbook. Severance is entirely voluntary on their part. When you see a severance offer say 2 weeks of pay for every year of service, you need to understand what you are actually buying. You are not being given a gift. You are entering into a new contract called a separation agreement. In exchange for that cash, you are signing a general release of claims. You are agreeing that you will never sue them for age discrimination, wage theft, harassment, or wrongful termination. You are selling your right to justice. This is where the Performance Improvement Plan, PIP, becomes weaponized. The PIP is rarely about improving performance. It is about manufacturing evidence. If a company wants to fire you but fears a lawsuit, they put you on a PIP. They set impossible goals. Increase sales by 50% in 14 days. When you inevitably fail, they have a paper trail. See? We tried to help, but they couldn't do the job. They use this documentation to justify a low severance offer or to fight your unemployment claim. If you are placed on a PIP, you need to recognize that you are likely already fired. You just haven't left the building yet. Your strategy should shift immediately from trying to hit the goals to negotiating the exit. You can sometimes go to HR and say, "Look, we both know this isn't working. Instead of dragging this out for 60 days on a PIP, why don't we agree to a transition plan where I leave in 2 weeks, and you pay me those 60 days as severance?" This is a cash for keys approach. It saves them the headache of documenting your failure, and it saves you the humiliation. Many HR departments will take that deal because it reduces their risk of you suing them later. We also need to discuss clawbacks. This is the zombie hand reaching up from the grave to grab your wallet. A clawback provision allows the company to demand the return of money they already paid you. This is common with signing bonuses, relocation packages, and tuition reimbursement. Usually the terms are, if you leave within 12 months, you must repay 100%. If you leave within 24 months, you repay 50%. Let's say you got a $20,000 signing bonus. You spend it on a new car. 8 months later, the job is a nightmare. You quit. They will send you a bill for $20,000. If you don't pay, they can send it to collections or sue you. But here is the detail that catches people. Does the clawback apply if they fire you? If the contract says, employee must repay if employment is terminated for any reason, then yes, they can fire you without cause, layoffs, restructuring, and still demand you pay back the bonus. That is an insult to injury. You lose your job and you owe them 20 grand. You must negotiate this clause to say, repayment obligation only applies if employee resigns without good reason or is terminated for cause. This protects you. If they lay you off, you keep the bonus. If you quit because they cut your pay, you keep the bonus. Finally, consider the tax implications of your exit. Severance is taxed as supplemental income, often withheld at a higher flat rate initially. But if you sue for emotional distress or physical injury, in rare cases, that money might be treated differently by the IRS. The structure of the settlement matters. There is one final trapdoor in the termination process. It is the mechanism that prevents you from ever having your day in court, even if the company broke every law in the book. It effectively privatizes the justice system and tilts the tables so far in the employer's favor that winning becomes statistically improbable. I am talking about mandatory binding arbitration and the class action waiver. You probably signed this on day one without reading it. It means if they steal your wages, harass you, or discriminate against you, you cannot go to a public judge and jury. You have to go to a private conference room and plead your case to a hired arbitrator, who is often paid by the very company you are fighting. In the next part, we are going to expose the arbitration racket. We will look at how companies use it to silence victims, hide systemic abuse, and keep their dirty laundry out of the public record. And we will see if there is any way to opt out. Welcome to the shadow legal system. If you thought the invention assignment clause was invasive because it claims your ideas, mandatory binding arbitration is existential because it claims your civil rights. It is the clause that unplugs the justice system and replaces it with a corporate conference room. Most Americans grow up believing that if they are wronged, if their employer steals their wages, discriminates against them based on race, or creates a hostile work environment, they have a constitutional right to take that grievance to a judge and a jury of their peers. They believe that the court system is a public forum where the truth comes out and precedent is set. When you sign an employment contract with a mandatory arbitration clause, you are voluntarily waiving that right. You are agreeing that you will never set foot in a public courtroom. Instead, your dispute will be heard by a private arbitrator. This arbitrator is usually a retired judge or a specialized attorney. They are not a public servant. They are a private service provider. Here is why this matters. In a public court, proceedings are open. If a company has a history of racially abusing its staff, the public learns about it. Journalists can report on it. Other victims see the news and realize they are not alone. It creates a record. Arbitration is confidential. It happens behind closed doors. The evidence is sealed. The outcome is often kept secret. This allows companies to settle individual cases of harassment or fraud quietly, without ever fixing the systemic culture that caused them, because the public reputation of the brand remains spotless. But the deeper issue is the repeat player effect. Think about the economics. You, the employee, will likely only be involved in one arbitration case in your entire life. The large corporation you are suing might have 50 cases a year. The arbitration firm knows that the corporation is a steady source of revenue. The employee is a one-time customer. While arbitrators strive for impartiality, statistical trends have historically shown that repeat players, the companies, tend to get more favorable outcomes than one-off individuals. It is subtle, but the pressure exists. If an arbitrator rules too harshly against a major bank, that bank might simply strike them from the list of preferred arbitrators for the next case. Furthermore, in arbitration, your rights to discovery are severely limited. In a real lawsuit, you can force the company to turn over thousands of emails, Slack messages, and internal memos to prove your case. In arbitration, the arbitrator decides what evidence you get to see. If they say no to your request for the CEO's emails, you have almost no recourse. And unlike a court decision, which can be appealed to a higher court if the judge makes a legal error, arbitration decisions are almost impossible to overturn. Even if the arbitrator gets the law wrong, you are usually stuck with the result. Now, combine this with the class action waiver. This is the divide and conquer strategy weaponized. Imagine a scenario where a massive retail chain requires its employees to undergo a security check every day before they leave the store. This check takes 15 minutes. The employees are off the clock, so they aren't paid for this time. 15 minutes of unpaid labor at minimum wage might only be $3 or $4 per person. If you go to a lawyer and say, "My boss owes me $4, the lawyer will laugh. It costs thousands of dollars to file a lawsuit. It makes zero economic sense to sue for $4. The company knows this. They are counting on it. However, if that company has 100,000 employees, and they steal $4 from each of them every single day, that is massive wage theft. It adds up to millions of dollars in stolen wages. In a public court, those employees could band together in a class action lawsuit. The lawyer takes the case because a percentage of millions is a huge payday. The company gets punished. The workers get paid. The class action waiver in your contract forbids you from joining a group, forces you to fight alone. It says, you must arbitrate your claim individually. By doing this, the company effectively immunizes itself against consequences for small-scale, widespread abuse. They know you won't sue for $4 alone, and they have made sure you can't sue together. But there is a twist in this narrative. The legal landscape is shifting beneath our feet, and you need to know about two specific developments: the opt-out loophole and the mass arbitration counterattack. First, the loophole. Many states have frowned upon forced arbitration, so companies, to avoid having their contracts thrown out entirely, often include an opt-out provision. It is usually buried in the final paragraphs. It will say something like, "You may opt out of this arbitration agreement by sending a written notice to the legal department within 30 days of signing this agreement." Almost nobody does this because almost nobody reads the contract that far. But if you send that email, subject line, "Opt out of arbitration agreement," you effectively reserve your right to sue them in court later. You don't have to give a reason. You just have to send the notice. It is the single most valuable email you can send during your first month, and it costs you nothing. Preserves your leverage. Second, the counterattack. A new strategy has emerged called mass arbitration. Since companies insisted that every employee must fight alone, lawyers called their bluff. A few years ago, thousands of gig workers for companies like DoorDash and Uber, who were barred from class actions, decided to all file for arbitration at the exact same time. Here is the kicker. In arbitration, the company usually has to pay the filing fees, which can range from $1,500 to $3,000 per case. When 5,000 workers filed individual claims simultaneously, the companies were suddenly staring at a bill for tens of millions of dollars just in filing fees, before a single lawyer even walked into a room. It was a financial catastrophe for the employers. They begged the courts to let them go back to a class action lawsuit, but the judges said, "No, you wrote the contract. You wanted individual arbitration. Now you have to pay for it." This mass arbitration leverage is changing the game, forcing companies to settle disputes they previously would have ignored. Also, we must mention the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act, signed into federal law in 2022. This is a crucial update. It invalidates pre-dispute arbitration agreements and class action waivers for claims involving sexual assault or sexual harassment. This means even if you sign the contract, if you are sexually harassed, the company cannot force you into the secret room. You have the choice to go to public court. You have the choice to join a class action. This law applies retroactively to contracts signed before the law was passed, as long as the claim arose after the law's enactment. It is a massive victory for transparency, but remember, it currently only applies specifically to sexual misconduct. If you are suing for race discrimination, age discrimination, or wage theft, the trapdoor is likely still sealed shut. So, what is the practical takeaway? When you receive your contract, Control F for arbitration. Read the section. Look for the opt-out window. Put a reminder in your phone. If you are past the window, understand that your best path to resolution in a dispute might not be a lawsuit, but a negotiated settlement where you leverage the threat of mass arbitration or public exposure, knowing that the company is desperate to keep things quiet. We have now covered the legal armor. We have discussed how they hire you, how they fire you, how they silence you, and how they own your ideas. Now, we need to talk about the reason you are doing all this in the first place: the wealth. I am not talking about your base salary. Base salary keeps the lights on. Wealth, generational wealth, comes from equity, stock options, RSUs, the golden handcuffs. But here is the ugly truth. Most employees who are granted stock options never see a penny from them. They don't understand vesting cliffs. They don't understand the difference between an ISO and an NSO. And they get crushed by a surprise tax bill that is higher than their annual income. They don't know what a liquidation preference is, which means the investors get paid 3x their money before the employees get a single dime. In the next part, we are going to deconstruct the complex world of employee equity. We will explain why 10,000 shares might be worth $0 and how to spot a dilution trap that washes away your ownership stake overnight. This brings us to the most seductive and misunderstood component of modern compensation: equity. For decades, the Silicon Valley dream has been sold on a simple premise. Take a lower salary today in exchange for a lottery ticket that will make you a millionaire tomorrow. But the contract you sign regarding these stock options is often a labyrinth of financial engineering, designed to protect the investor class while leaving the employee holding an empty bag. Let's start with the psychological trick recruiters use on day one. They will slide a piece of paper across the table that says you are being granted 10,000 shares. Sounds like a fortune. Your brain immediately anchors to that number. 10,000 of anything sounds like a lot. But 10,000 shares is a meaningless number without the denominator. If there are 10 million outstanding shares, you own 0.1% of the company. If there are 10 billion outstanding shares, you own microscopic dust. You must never accept an equity offer based on the number of shares alone. You must ask two specific questions. What is the total number of fully diluted outstanding shares? And what is the current 409 valuation? Without this data, you are negotiating in the dark. You need to know the percentage of the pie you are actually getting. But even if you get a healthy percentage, you don't actually own anything yet. You have been given options, specifically, the right to buy stock at a set price, known as the strike price. This distinction is critical. You are not being given shares. You are being given the privilege of purchasing shares later. This purchase is called exercising your options. Here is where the vesting schedule and the cliff come into play. The industry standard is a 4-year vesting schedule with a 1-year cliff. This means that for the first 12 months of your employment, you earn absolutely nothing. If you get fired or quit on day 364, you walk away with 0 shares. On day 366, the day after your 1-year anniversary, 25% of your options suddenly vest. This is the cliff. It is a retention mechanism designed to lock you in for at least a year. Let's run a deep dive scenario on the golden handcuffs. Imagine you have worked at a successful startup for 3 years. You have vested 75% of your options. You want to leave because the culture has become toxic. You check your contract and find the post-termination exercise period. In most standard contracts, this is 90 days. This means if you quit today, you have exactly 90 days to write a check to the company to buy your shares. If the strike price is $1 and you have 100,000 shares, you need to come up with $100,000 cash within 3 months. If you don't have the cash, you forfeit the shares back to the company. They vanish. This effectively traps employees who are paper rich but cash poor. They cannot afford to leave their job because they cannot afford to buy their own equity. But the nightmare scenario, the one that has bankrupted legitimate millionaires, is the tax trap known as the alternative minimum tax or AMT. Imagine this. You exercise your options. You buy stock worth $10 a share for a strike price of $1. You have a paper gain of $9 per share. Even though you haven't sold the stock, even though you haven't seen a single dollar of actual profit, the IRS may view that spread as taxable income under AMT rules. There are horror stories from the dot-com crash where engineers exercised millions of dollars in stock, triggering a massive tax bill of $300,000 or $400,000. They didn't sell the stock because they believed it would go higher. Then the market crashed. The stock went to zero, but the IRS bill was still due. They owed taxes on money they never truly had, driving them into bankruptcy. This is why understanding the difference between incentive stock options, ISOs, and non-qualified stock options, NSOs, is not just administrative trivia. It is financial survival. Now let's talk about dilution. This is the water rising in the room. Every time a company raises money from venture capitalists, they issue new shares. This increases the total number of shares in the pie. If you own 1% of the company today, and the company raises a Series B, Series C, and Series D round, your 1% might shrink to 0.2%. Smart contracts include anti-dilution provisions for investors, guaranteeing their percentage stays the same. Employee contracts almost never have this. You get diluted, They don't. You need to look for a refresh clause or ask during annual reviews for equity top-ups to maintain your ownership percentage. Otherwise, your slice of the pie is constantly getting thinner. But the ultimate trap, the one that renders everything else irrelevant, is the liquidation preference. This is the term that dictates the order in which people get paid when the company is sold. Investors typically negotiate a 1x or 2x liquidation preference. This means they get their money back before any common shareholders, that's you, see a dime. Consider a case study. A startup raises $50 million from investors. The company struggles and eventually sells for $40 million. On the headline, it looks like a $40 million exit. You might think, I own 1%, so I get $400,000. Wrong. Because the investors have a 1x liquidation preference, they are entitled to get their $50 million back first. Since the sale price is only $40 million, the investors take all of it. The founders get zero. The employees get zero. Your stock options are worthless even though the company sold for millions. This is called the preference stack, and it is completely invisible to you unless you ask to see the capitalization table or the specific class of shares you are being offered. Now let's briefly touch on RSUs, or restricted stock units. If you are joining a larger late-stage company, you will likely get these instead of options. RSUs are better in one specific way. You don't have to buy them. They are given to you outright as they vest. However, they are taxed immediately as ordinary income the moment they vest. If you get $100,000 worth of RSUs vesting this year, the IRS treats it exactly like you got a $100,000 cash bonus. The company will usually sell to cover, meaning they automatically sell a portion of your shares to pay the taxes and give you the rest. It is a safer bet than options, but it lacks the explosive tax-advantaged upside of early-stage ISOs. There is also a growing trend of double-trigger vesting for RSUs in private companies. This means your shares don't actually vest until two things happen. 1. You stay for the required time trigger, and 2. The company goes public or gets acquired, liquidity trigger. This sounds fine until you realize the liquidity trigger might typically have an expiration date, often 7 to 10 years. If the company stays private for 11 years, your RSUs might expire worthless even though you did the work. You need to check the expiration date on the double trigger. Finally, you must check for a clawback on vested equity clause. Some aggressive contracts state that if you are terminated for cause, remember how broadly that can be defined, the company has the right to repurchase your vested shares at the original strike price. That means you could work there for 4 years, earn your equity, get fired because you argued with a new manager in subordination/cause, and the company can forcibly buy back your stock for pennies, effectively erasing 4 years of wealth accumulation. This is draconian, but it exists in the fine print. Understanding equity is about understanding your place in the capital structure. You are a common shareholder. Investors are preferred shareholders. In the world of finance, preferred means paid first. You are effectively betting that there will be enough money left over after the VIPs eat to feed the rest of the table. But while we have focused heavily on the financial and legal mechanics of the contract, there is a behavioral aspect that is equally legally binding. These are the clauses that dictate your morality, your private life, and your ability to have a second stream of income. In the gig economy, everyone has a side hustle. Everyone has a passion project. But your contract might contain a conflict of interest or moonlighting policy that gives your employer the right to fire you for what you do on Saturday night. In the next part, we are going to expose the hidden rules of conduct. We will look at morals clauses. Yes, they are real. And we will break down exactly how to navigate moonlighting bans so you can keep your side income without getting walked out of the building. We have arrived at the section of the contract that attempts to govern not just your labor, but your lifestyle. It's the part that asks the question, do you belong to us? In the era of the side hustle, the gig economy, and the remote work revolution, the clash between an employee's desire for financial autonomy and an employer's demand for total subservience has never been louder. Let's start with the moonlighting clause, often formally labeled exclusive services or outside employment. Historically, companies expected you to show up at 9, leave at 5, and what you did in the evening was your business. That social contract has frayed. Many standard employment agreements now contain language explicitly prohibiting you from engaging in any other employment, business, or consulting activity, regardless of whether it conflicts with your job. The text usually reads, "Employee agrees to devote their full business time, attention, and energies to the company, and shall not engage in any other business activity without prior written consent. This is the full business time trap. If you drive for Uber on the weekends, sell vintage clothes on Depop, or monetize a YouTube channel, you are technically in breach of this contract. You could be fired for cause. Why do companies care if you walk dogs on Sunday? It comes down to the legal concept of the duty of loyalty. In many states, even without a written contract, employees owe a fiduciary duty to their employer not to compete with them or act against their interests. But companies take this further, arguing that any outside energy expenditure detracts from your focus on them. They want your best energies, not your leftover energies. This friction has exploded with the overemployment trend, white-collar workers secretly working 2 full-time remote jobs simultaneously. While this sounds like a clever life hack to double your income, the legal ramifications are severe. It is not just a breach of contract. In some jurisdictions, it can be prosecuted as theft of time or wire fraud, especially if you are logging hours for 2 companies at the exact same moment. There was a publicized case of a software developer who outsourced his own job to a team in China for a fraction of his salary, spending his days watching cat videos while collecting a 6-figure paycheck. He was eventually caught because the VPN log showed his login coming from Shenyang, not his home office. While he was fired, the company also explored suing him for the return of all wages paid, arguing he never actually performed the services he was paid for. So, how do you protect your side hustle? The answer is disclosure and carve-out. During the negotiation phase before you sign, you must disclose your existing projects. You say, I have a small consulting business that I run on weekends. It does not conflict with this role. I need a carve-out in the exclusive services clause permitting this specific activity. Most reasonable employers will agree to this if it is in writing. If you hide it and they find out later and they will via background checks or a slip-up on LinkedIn, it looks like deception. Transparency converts a potential firing offense into a sanctioned agreement. Now let's pivot to conflicts of interest. This is broader than just working for a competitor. A conflict exists if your personal interests interfere with your ability to act in the company's best interest. Imagine you are a procurement manager. Your job is to select a vendor for office supplies. You choose a company owned by your cousin. Even if your cousin offers the best price, this is a conflict of interest because your judgment is compromised by the relationship. Contracts often require you to disclose potential conflicts. If you fail to disclose that your spouse works for a major competitor, or that you own stock in a vendor, you can be terminated for cause, stripping you of severance, even if you never actually did anything wrong. The failure to disclose is the offense. But the most chilling evolution in modern contracts is the democratization of the morals clause. 20 years ago, morals clauses were reserved for movie stars and athletes. A studio needed the right to fire an actor if they committed a crime that ruined the movie's marketability. Today, these clauses are appearing in contracts for teachers, bank tellers, and marketing coordinators. The language is intentionally vague. Company may terminate this agreement if employee engages in conduct that brings the company into public disrepute, scandal, or ridicule, or reflects unfavorably on the company's reputation. Reflects unfavorably. That could mean anything. Could mean getting a DUI. It could mean getting into a shouting match at a Little League game that goes viral on TikTok. It could mean posting a controversial political opinion on Facebook. This brings us to the social media policy, often incorporated by reference through the employee handbook. There is a pervasive myth in the United States that freedom of speech protects you at work. It does not. The First Amendment protects you from the government persecuting you for your speech. It does not stop a private corporation from firing you because they didn't like your tweet. Unless you are a public sector employee, your boss can absolutely fire you for your political posts, your jokes, or your hot takes, if they decide it hurts the brand. The disclaimer "views are my own" in your Twitter bio offers zero legal protection. It is a placebo. If your profile links to your employer, or if you are publicly known as an employee of that company, your speech is their liability. However, there is one massive, federally protected exception that every worker must know. Section 7 of the National Labor Relations Act, NLRA. Section 7 protects concerted activity. This means you have the right to discuss wages, hours, and working conditions with your coworkers. If you go on Twitter and write, "My boss is a jerk because he creates a hostile safety environment and refuses to pay us overtime," that is likely protected speech. The National Labor Relations Board, NLRB, views that as you trying to organize or improve working conditions. But if you go on Twitter and write, My boss is a jerk and his product is garbage. That is likely not protected. That is disparagement. The line is thin. To be protected, the speech usually needs to be about mutual aid or protection, involving other employees, not just a personal gripe. In 2023, the NLRB issued a landmark decision in Stericycle Incorporated, which shifted the burden heavily back onto employers. The board ruled that work rules are unlawful if they have a reasonable tendency to chill employees from exercising their Section 7 rights. This means broad civility codes, rules like be positive at all times, or do not post negative comments, might now be illegal because they stop workers from discussing bad working conditions. Yet, despite this ruling, companies still enforce strict social media policies. They rely on the fact that you probably won't file a charge with the NLRB. They know that firing you for a viral moment is easier than dealing with the PR fallout. Here is the imagine if scenario. You are a mid-level manager. You attend a protest on a Saturday. You are not wearing company gear. A news camera captures you shouting at a counter-protester. The clip goes viral. The internet identifies you. By Monday morning, your company's Twitter account is flooded with thousands of messages demanding your termination. Under a standard at-will contract with a morals clause or reputational harm policy, you are gone. HR will call you and say, "Your presence here is becoming a distraction. It doesn't matter if you were right. It doesn't matter if it was your day off. You became a liability." The only real protection against this is a contract that explicitly defines cause to exclude private, lawful conduct outside of work hours. But getting a company to agree to that is incredibly difficult unless you are a high-leverage executive. For the average worker, the strategy is defensive. You must scrub your digital footprint. You must understand that in the digital age, there is no such thing as off the clock. Your contract has effectively expanded the workplace to include every server where your name appears. So we have covered the restrictions on your time, your voice, and your behavior. But there is one final classification of worker that bypasses many of these rules, or so they think. Millions of Americans are not employees at all. They are independent contractors. They are told they are their own bosses. They are told they have freedom. But often, this label is a lie designed to strip them of benefits, overtime pay, and legal protections. In the next part, we are going to dive into the misclassification crisis. We will look at the IRS control test, the new Department of Labor rules, and how to tell if you are actually a disguised employee who is owed thousands of dollars in back taxes and unpaid benefits. This is perhaps the greatest sleight of hand in the modern American economy. It is a financial magic trick where a company makes an employee disappear and replaces them with a vendor, saving themselves 30% in labor costs while effectively transferring their tax burden onto your shoulders. We are talking about the classification of the independent contractor, also known as the 1099 worker. There is a romanticized narrative around being a contractor. You are your own boss. You set your own hours. You have freedom. And for a true freelancer, someone who runs a business, has multiple clients, and sets their own rates, this is true. But for millions of Americans, the independent contractor label is a lie. It is misclassification. And it is stealing money from your pocket every single pay period. Here is the math that HR departments hope you never do. When you are a W-2 employee, your employer pays half of your FICA taxes, Social Security, and Medicare. That is 7.65% of your income that they cover. They also pay for unemployment insurance, workers' compensation insurance, and often subsidize your health insurance and 401k. When you are a 1099 contractor, you are responsible for the entire FICA tax bill. This is the self-employment tax, and it is 15.3% of your earnings. You get zero health benefits. You get zero paid time off. You get zero unemployment protection. If they fire you on Tuesday, you don't get a severance check. You just stop getting invoices paid. When a company hires you as a contractor, but treats you like an employee, they are essentially asking you to subsidize their business model. They are shifting their overhead costs onto you. So, how do you know if you are being scammed? It doesn't matter what your contract says. You can sign a document in bold red ink that says, "I am an independent contractor," and the IRS can still look at the relationship and say, "No, you are an employee." The law looks at the reality of the work, not the title on the PDF. For decades, the standard was the IRS common law test, which focused primarily on control. It boils down to three main pillars: behavioral control, financial control, and the type of relationship. Let's apply the behavioral control test to a deep dive scenario. Imagine you are hired as a consultant graphic designer. Does the company tell you exactly what hours to work? Do they require you to be in the office or on Slack from 9 a.m. to 5 p.m.? Do they provide you with a company laptop and forbid you from using your own? Do they give you step-by-step instructions on how to do the design, rather than just telling you what the final result should be? If the answer is yes, you are likely an employee. A true independent contractor is paid for the result, not the method. If I hire a plumber, I don't tell him which wrench to use or exactly how to stand while he fixes the pipe. I just pay him to fix the pipe. If your boss is micromanaging your process, they are exercising behavioral control, which is the hallmark of employment. Next, look at financial control. Can you realize a profit or loss? A true business owner can lose money. They might buy expensive equipment, market themselves, and fail to get clients. If you are a contractor but you have zero expenses, zero risk of loss, and are paid a guaranteed hourly wage just like the person sitting next to you, you fail the financial control test. Are you allowed to work for other clients? If your contract prohibits you from taking on other work, you are economically dependent on one entity. That looks a lot like employment. This issue has become so pervasive that the Department of Labor (DOL) issued a new final rule that went into effect in March 2024, reinforcing the economic reality test. This test looks at the totality of the circumstances. It asks a fundamental question. Is the worker in business for themselves, or are they economically dependent on the employer for work? Consider the permalancer phenomenon common in the tech and media industries. You walk into a hip office. You sit at a desk. You have a company email address. You have a manager. You go to the Christmas party. You work there for 2 years. But your paycheck comes from a third-party staffing agency, or you invoice them directly. You do the exact same work as the person sitting to your left, but they get health insurance and stock options and you get nothing. This is often a legal misclassification. The company is treating you as a permanent part of their infrastructure, but labeling you as a temporary vendor to avoid paying benefits. Why should you care? Beyond the taxes, think about your intellectual property. As we discussed earlier, work-made-for-hire laws generally apply automatically to W-2 employees. But for independent contractors, if the contract doesn't explicitly assign the IP to the company, the contractor might actually retain ownership of their work. This is a double-edged sword that sometimes panics companies into forcing you to sign even more restrictive IP agreements as a contractor than you would as an employee. But the biggest risk is the lack of safety net. During the global pandemic, millions of gig workers discovered the hard way that because they were 1099s, they were initially ineligible for standard state unemployment benefits. The government had to create emergency programs just to keep them afloat. If you are misclassified, you are walking on a tightrope without a net. So what can you do if you realize you are a disguised employee? First, there is the soft approach. You negotiate. You say, based on the scope of work and the level of control you require, this role looks like a W-2 position. I would prefer to be categorized as an employee. If they refuse and insist on 1099, you must calculate your freelance premium. You cannot accept the same hourly rate as a salary equivalent. If the job pays $50 an hour as a W-2, you need to charge at least $75 or $80 an hour as a 1099 to cover your extra taxes, health insurance, and lack of paid time off. If they offer you the same rate, you are effectively taking a 30% pay cut. Do not let them anchor you to the salaried number. Then there is the nuclear option. This is Form SS-8, Determination of Worker Status for purposes of federal employment taxes and income tax withholding. You can file this form with the IRS. You essentially tell the government, here is my situation. Here is how they control me. Am I an employee? The IRS will investigate. They will send a letter to the employer asking for their side of the story. If the IRS determines you have been misclassified, the consequences for the employer can be devastating. They may be liable for years of back taxes, unpaid overtime under the FLSA, and massive penalties. It is a bridge-burning move. You will almost certainly be fired, but it is a powerful tool if you are leaving a job and realize you were exploited for years. Furthermore, you can file a wage claim with your state's Department of Labor. If you were misclassified, you might have been denied overtime pay. Contractors don't get overtime, 1.5x pay, for working over 40 hours. Employees do. If you worked 60 hours a week for 2 years as a contractor, the company might owe you thousands of dollars in unpaid overtime wages. The trend is shifting. States like California, with the famous AB 5 law, New Jersey and Illinois are cracking down hard on this. They want the tax revenue. They want workers protected. But the companies are fighting back, rewriting contracts to be just vague enough to skirt the rules. They will try to make you sign an indemnification clause. This clause says, if the IRS decides you are an employee, you agree to pay the company back for any taxes or penalties they owe. This is the ultimate audacity. They break the law by misclassifying you, and then they try to make you sign a contract saying you will pay their fine if they get caught. Never, ever sign an indemnification clause regarding worker classification. It is a massive red flag that suggests they know they are operating in a gray area. We have now dissected the anatomy of the trap. We have looked at the offer letter, the non-compete, the IP assignment, the termination clauses, the arbitration handcuffs, the equity labyrinth, the morals clauses, and the contractor con. You now see the matrix. You see the code behind the job offer. But knowledge is only potential power. Power is execution. Power is knowing what to say when you are sitting in that chair. The offer is on the table, and your heart is racing. Most people are terrified to negotiate because they think the offer will be rescinded. They think asking for changes makes them look difficult. The opposite is true. Negotiating a contract shows you are a professional who understands value. High-level companies expect you to push back. If you just sign, you signal that you are desperate. In the final part of this masterclass, we are going to give you the playbook. I am going to give you the specific scripts, the psychological levers, and the red line strategy to take everything we have learned and turn it into a better, safer, and richer contract for yourself. We are going to teach you how to ask for what you want and actually get it. This is the moment where the rubber meets the road. You have the knowledge. You understand the traps. You see the invisible strings. Now you have to do the one thing that terrifies 99% of job seekers. You have to tell them no, and then you have to tell them how to fix it. The fear that paralyzes most people is the fear of the rescinded offer. You think, if I ask for changes to the contract, they will get angry, rip up the offer letter, and I'll be left with nothing. Let me shatter that myth right now with data. In professional industries, rescinding an offer because a candidate politely negotiated contract terms is statistically rare. It costs a company thousands of dollars in recruiter fees, interview hours, and background checks just to get you to the offer stage. They want you. They are emotionally invested in you. You have more leverage in this specific window, between the verbal yes and the written signature, than you will ever have again. Negotiating a contract does not make you look difficult. It makes you look competent. If you are being hired for a role that requires judgment, strategy, or handling money, blindly signing a bad contract actually signals to them that you might not be diligent enough for the job. You are demonstrating your professional worth by how you handle your own business. So, how do you do it? Do not just send an email listing your complaints. That feels like a demand. Instead, use the red line method. Ask HR for the employment agreement in a Microsoft Word document, not a PDF. Tell them, I have a few minor comments and clarifications I'd like to mark up for review. Open the document. Turn on track changes. This is a feature that highlights every edit you make in red. When you delete a sentence that says, company owns all inventions created on employees' personal time, do not just delete it. Add a comment bubble on the side. In that bubble, write your justification. Do not say, I don't like this. Say, this clause is overly broad and conflicts with California Labor Code Section 2870. I have adjusted it to comply with state law. See the difference? You aren't being difficult. You are helping them be legally compliant. You are framing your objection as a solution. Let's go through the specific scripts for the battles we have discussed in this series. Scenario 1, the standard boilerplate defense. You send your red lines. HR emails back. Sorry, we can't change this. It's our standard template for everyone. Legal won't approve edits. Do not fold. This is the first test. Your script is, I completely understand the need for consistency. However, my review has highlighted a few specific terms that are non-standard for the market and pose a unique risk to my specific situation. I am very excited to join the team, and I am confident we can find a middle ground on these few points. Can we schedule a brief 10-minute call to walk through them? By getting them on the phone, you humanize the request. It is much harder for them to say no to your voice than to your email. Scenario 2, the non-compete. The contract bans you from the entire industry for 2 years. You want to narrow it. Your script. I understand the companies need to protect trade secrets. However, as currently written, This non-compete would effectively prevent me from earning a living in my profession anywhere in the country. I propose narrowing the scope to direct competitors, defined as companies that derive more than 50% of their revenue from. This protects your interests without restricting my fundamental right to work. Scenario 3. The signing bonus clawback. The contract says you must repay the full $20,000 if you leave within 2 years. Your script. I am comfortable with a repayment obligation, but it should be amortized. If I leave after 12 months, I should only owe 50%. Furthermore, the repayment should only be triggered if I resign without good reason or am terminated for cause. If the company eliminates my position through layoffs, I should not be penalized by having to write a check back to you. This is a reasonable request that appeals to fairness. Most reasonable HR directors will agree that a layoff shouldn't trigger a clawback. Scenario 4. The intellectual property dragnet. You have a side business or a novel you are writing. Your script for the prior inventions exhibit. I have listed my existing projects in Exhibit A. I also need to clarify that the invention assignment clause applies only to work done using company resources or directly related to my specific duties, consistent with statutory exceptions. I want to ensure we avoid any future confusion regarding ownership of my personal creative work. Scenario 5. The cause trap. The definition of cause is too broad. Your script. The current definition of cause includes any violation of company policy. Given the volume of policies, I could inadvertently trigger this with a minor administrative error. I propose changing this to material and willful violation of major company policies after written notice, and a failure to cure such violation within 30 days. This ensures we are aligned on performance management. Now let's talk about the give and take. You will not win every point. That is negotiation. You need to know what matters. If they refuse to budge on the arbitration clause because the Supreme Court usually backs them up and they want to avoid class actions, let it go, but use it as a trading chip. Okay, I will concede on the arbitration requirement, but in exchange, I need the non-compete duration reduced from 2 years to 1 year. You are trading a procedural loss for a career freedom win. We also need to discuss the signing authority. The recruiter you are talking to often does not have the power to change the contract. They have to go to legal. You need to equip the recruiter with the arguments to fight for you. Tell the recruiter, I want to sign this today. I am ready to go. I just need this one clause regarding the IP assignment cleared up so I don't have issues with my side business. Once that is updated, I'm in. Now the recruiter goes to legal and says, hey, we can close this candidate today if you just change this one sentence. You have made the recruiter your ally because their goal is to close the rec. Finally, remember the walk-away price. This is your best alternative to a negotiated agreement. If a company absolutely refuses to narrow a terrifyingly broad non-compete, or refuses to clarify that they don't own your personal screenplay, you have to be willing to not take the job. And I know that is hard. I know you have bills. But signing a contract that allows them to sue you for $50,000 or steal your patent is not taking a job. It is taking on a liability. Sometimes the best deal is the one you don't sign. Conclusion. We have been on a long journey together. We started with the disclaimer that this isn't legal advice, and we ended with the tactical scripts to act as your own best advocate. The employment contract is the most important financial document you will sign outside of a mortgage. It dictates your income, your freedom, your reputation, and your future. For too long, the system has relied on information asymmetry. They have the lawyers, you have the anxiety. They have the templates, you have the confusion. But now the asymmetry is gone. You know what integration clause means. You know the difference between ISO and NSO. You know that cause needs a cure period and that 1099 usually means pay your own taxes. You are no longer just an employee. You are a business of one. You are selling your services to a client, the employer. The contract is the terms of that sale. Treat it with the respect it deserves. Read every line. Google every term you don't understand. Pay a local employment lawyer $500 to review it if the stakes are high. It is an investment that pays off 10 times over if it saves you from a non-compete lawsuit. Do not let the excitement of the offer blind you to the reality of the paper. The honeymoon phase of the job will end. The contract will remain. The corporate world is designed to extract maximum value from you at minimum cost and minimum risk. Your job is not to be cynical, it is to be protected. Take these scripts. Use these red lines. Own your value. And when you sit down at that table, pen in hand, looking at the dotted line, you won't be trembling. You will be smiling, because you read the fine print. If you found value in this deep dive masterclass, if this saved you from a bad clause or helped you negotiate a better signing bonus, you know what to do. Share this with a friend who is job hunting. Knowledge is the only leverage that multiplies when you share it. Now go get what you are worth.